questions that were put to the delegation as part of the second list of issues. You have the floor.
Thank you very much. I would like to thank especially Mr. Chair for allowing me this opportunity to answer on behalf of the delegation. So this morning, we received a lot of questions from the committee members, and some of the commonalities that we see across the questions, I would like to provide you with my answer as the head of the delegation, and if the time allows, we will try to focus on key specific issues. A lot of members of the committee posed very specific and concrete questions. And in relation to those questions, what I would like to say is the following. The Republic of Korea, I would like to just go over the judiciary and the legislative process of the country. In accordance with the covenant, we are trying very hard to make sure to implement the recommendations proposed by the committee, and especially in relation to legislation. I would like to point out the fact that a lot of legislations have actually taken place, and there are certain legislations that are currently being pursued. As you are well aware, Korea has a constitution that provides the provisions for the fundamental rights of individuals, and these fundamental basic rights are to be limited only by the laws. But the fundamental essence of the fundamental rights or basic rights are not to be infringed upon, as provided by the Constitution. So any legislations or laws that result in restricting such fundamental rights of individuals during the legislation process are subject to a disclosure. That information is disclosed to the public, and also the relevant legislative committee spends a lot of time looking at different aspects of the proposed laws. And in the legislation process, it is a process that ensures all the public opinion, the opinion of all the citizens are ensured and reflected. In the process of executing our laws, we make sure that there's an independent organization apart from the government, which is the Supreme Court, the court, and the Constitutional Court that look into the constitutionality of the legislations, and they do this in a very in-depth manner. There was a comment on the principle of proportionality. Review on the principle of proportionality is done judiciarily by the court and by the Constitutional Court, by referring to case examples or legislative examples of abroad and reflected information into the decisions and rulings. As for the Constitutional Court's decision on the dissolution of the political party in Korea, or disbandment of the political party, the Constitutional Court, after making a decision on disbandment of the political party, disclosed this information, all details of the decision, and this information was fully disclosed to the public. During the process of the decision-making or the trial, all of the existing examples across the world were reviewed. And there was a very long process of a review in an in-depth manner. And the Constitutional Court, as a result of the process, came to that independent decision on disbandment of the political party. Next, in relation to abolition of capital punishment system, up until very recently, we were very easily able to see in newspapers and articles a lot of articles about pros and cons for the abolition of the capital punishment system. Our criminal system that recognizes such capital punishment system, if that is to be changed, we have to have a legislative process in practice. So a majority of the National Assembly have to vote in favor of such legislation. Therefore, what I refer to as national consensus, it's not only referring to just a simple form of public opinion. This is related to the system of the Republic of Korea in relation to the judiciary as well as the legislative process. Of course, everything will be done in accordance with the covenant, and there are certain areas that we would have to look further into in order to ensure its compatibility with the covenant. It is not that we disrespect or disregard such comments and recommendations of the committee. Under this constitutional system, laws and regulations are amended, revised, and enacted. So I just want to emphasize that point once again. Let me stress again that various matters that are drawing a lot of interest from NGOs and so forth. This information has already been disclosed and revealed through the media, and a lot of in-depth discussions and debates have already taken place. So we ensure such broad disclosure information to the public to form opinions and to ensure compatibility with the covenant. And these efforts are underway as we speak. So let me now give you specific answers to the questions.
My name is Kyungwon Cha from the MOJ. We received a lot of questions, but we do not have much time left. So we would like to summarize and present the key opinions of the delegation. First, regarding the questions raised by Mr. Shani, we would like to provide you with answers concerning confinement and the protection of juveniles and so forth. The MOJ will provide a response. My name is Junyan Kim from MOJ, Human Rights Division. I would like to thank the members of the committee for raising questions to us. And of the questions raised by Mr. Shani, the first one was regarding the duration of detention concerning the habeas corpus protection. In the case of the people subject to investigation that are detained, without a delay, we determine whether an arrest warrant can be issued against that person. As you know, we are making sure that the maximum of 48 hours rule is observed. As such, during investigation, within 48 hours, as expeditiously as possible, we are making a determination as to whether an arrest warrant will be requested. And if that request is not going to be made, we are immediately releasing that person. And at the same time, regarding the cases where people are released without the request of an arrest warrant, we are making a report to the court as to such cases. And within 24 hours, a judge of the court is supposed to examine a suspect before making a decision as to the arrest of that suspect. For all cases, even if a suspect himself or herself does not make a request, for all cases, judges will examine those cases to make a decision as to whether we are going to arrest that person or not. For a prompt decision, even on Saturdays and Sundays, such hearings are being held at the courts in Korea so that we can make decisions as to the necessity or the legality of putting the person under custody. So we are trying our best to make expeditious decisions. Next, regarding the duration of detaining immigrant detainees.
As for the protection facilities for the foreigners, we don't have any specific limit on the period. So there was a concern that the detention period may prolong. That question will be addressed by the immigration control officer later at a later point. Next, related to the juvenile cases. The days of the detention period not being reflected towards the final sentence, pretrial detention. There are two types of juvenile cases in Korea. One is related to the just equivalent to general criminal cases. It goes through the formal trial in order to make the judgment. And another case is where education or guidance are required for the juveniles, then it would be treated as an education disposition. The results and the effects of two different treatment are very different. In terms of protection of the juveniles, we provide education to correct their juvenile behaviors rather than providing them with the punishment. But of course, the pre-trial detention days, those days are of course counted towards the total sentencing day. But for the education disposition, that is not a criminal case to be treated. So we set a specific date for the detention of the juveniles. And we will need to have a certain period of days for providing education to the juveniles. So pretrial detention is actually different from the concept of education. So that is why those days are not counted towards the final sentencing period, final sentencing days, excuse me.
Next, regarding the protection of North Korean defectors, the response will be provided by the Supreme Court in Korea. My name is Hyunil Jin from the Supreme Prosecutor's Office. Regarding the Protection Center for North Korean refugees, and concerning the protection of the rights of those people, before we initiate investigation or inquiry, we inform them of the basis for such inquiry and the duration of that inquiry and the relief measures as well. And at the same time, human rights protection officers will have a one-on-one session with those people. Thank you.
Next, related to religious education, the answer will be provided by the Ministry of Education.
My name is Byung-gyu Kang from the Ministry of Education. In the case of the religiously affiliated schools, against the students' will, some religious classes could be opened and administered, and there was a question regarding that. As was mentioned, after the ruling from the Supreme Court of Korea, the government has provided guidelines as to the educational curriculum in Korea. For instance, if a religiously affiliated school is going to open and offer a religious class, an alternative class is supposed to be set up so that we can guarantee the right of choice to the students. And I would like to give you the updated status of this provision. As of today, religiously affiliated elementary and middle schools in Korea number 478, and of those schools, 43.7%, hence 209 schools offer religious classes. And of those 209 schools, the number of schools that have opened up alternative classes amounts to 74.6%, which is 156 schools. The other schools are the religious schools where students who go there chose to go there. So those are not the schools that are imposed on general students. Thank you.
통신기본법
In relation to the Framework Act on Telecommunication and Defamation, the answers are going to be provided by the Broadcasting Committee. I'm Ina from the Broadcasting Communication Committee of Korea. As you said before, the Constitutional Court
made a ruling that regarding Article 47. Paragraph 1 of the Telecommunications Business Framework Act, the concepts of the public interest and false information or false communication were against the principles of clarity and the principle of anti-over restriction. Hence, the court ruled this provision unconstitutional. As such, we took some follow-up measures, and we withdrew the public prosecution and took appropriate measures.
메르스 관련 사태 때에도 정부
not only the contents that were related to the government criticism against government during the MERS breakout, there were other contents that were deleted. Not only those type of deleted, there were some false information that was spreading on the internet, which led to confusion among the public and also the conflicts among various stakeholders. So the deliberation body and the police agency work together to respond to these problems on the internet. According to Article 44.7 in the Information Communication Act, I would like to now talk about the protective measures that we're taking. In order to make sure not to restrict the freedom of expression, we have a deliberation body, which is the Broadcasting Communication Deliberation Committee, which has been established according to the relevant laws of the state. And the independence of the committee is being ensured. Also, if there is a report on the rights violation, or if there is a clear evidence that the information is false, then actions are taken to remove that information, and detailed procedures are provided for in the relevant laws. The Constitutional Court ensures the objection system and the statement system, and based on the evidence that these are not related to the criminal procedures, ruled constitutional on the results of the deliberation committee. Next, in relation to decriminalization of expression of information that is based on true statement. Freedom of expression is very important, equivalent to the rights to reputation and privacy of individuals. Recently, internet, social media, and other communication technologies have advanced to a great extent, which is leading to an increase in terms of spreading information on the internet. And if there's an act that spreads information or facts that are not based that are based on true, so even if it is based on true statement, if it leads to severe undermining of the right to reputation of individuals, we would have to conduct a very cautious review of this. And for example, for the victims of sex violence, especially the child, if facts of crime are disclosed to the public, it could lead to severe violation of the rights to reputation of an individual. We have to understand the irreversibility of the damage done to the individual. And given the fact that the information spreads very quickly, we have a provision for aggravated punishment for this type of a crime. Thank you.
예, 다음.
Next, regarding the freedom of expression of public officials, the Ministry of Labor will provide a response. My name is Wan Lee from the Ministry of Employment and Labor. Government public officials, in accordance with the Constitution and relevant laws and regulations, have the obligation to remain neutral in terms of political orientation. That is why their political activities are prohibited.
공무원의
However, these provisions are not limiting the general freedom of expression of the public officials. In relation to the pension reform of the public officials, the government requested KGEU to refrain from being involved in collective action. As pursuant to the labor trade union law on public officials, this is an issue that is related to the collective act that is provided for in the relevant laws of the public officials.
예, 다음.
Next, regarding the National Security Act and the dismantlement of the UPP, responses will be provided by the Supreme Prosecutor's Office. My name is Hyun Il-jin from the Supreme Prosecutor's Office in Korea. Concerning the National Security Act, let me provide an answer to you. Article 7 of the National Security Act is with regards to the confrontation between the DPRK and the ROK. And under those circumstances, fundamental rights are restricted to a certain extent. The National Security Act exists in order to protect the existence of the nation. And if you have the knowledge that your activity is going to undermine the existence of a nation and the free democratic order and still goes on to engage in an activity that praises or propagates the ideology of North Korea, we apply the restriction according to the Constitutional Court and the court's decisions regarding the preservation of free democratic order. If there is a clear danger to cause harm to the basic order of free democracy, only under such circumstances the National Security Act provisions will apply. Next, let me move on to the dismantlement of the UPP. The Constitutional Court of Korea decided that the UPP, according to their political platform, pursues the ideology, the socialist ideology of North Korea, and they want to propagate that via violence, and they are taking proactive measures in order to attack the basic order of free democracy of the ROK. And that was the ruling that was rendered by the Constitutional Court of Korea. And they also attempted to destroy the essential national infrastructure of the ROK. And their charges were the incitement of an insurrection. Hence, the decision to disband the party was rendered.
예, 다음.
Next, in relation to migrant and foreigner protection, this answer will be given by MOJ. I'm Song So-young from MOJ. Member Shani, Mr. Shani asked about issue 15. According to the Immigration Control Act, protection is not unlimited in principle. We have to look at the violations of the Immigration Control Act, and in order to conduct investigation, we give maximum 20 days of detention for the person, including first 10 days and renewal of once renewal. And those people that are subject to deportation, for those cases where these people cannot be repatriated outside the country right away, they can be detained or protected until it becomes possible for them to depart the country. However, this period, for example, if a preparation is needed in order to arrange travel documents, or if there is a pending litigation, and if there are some grievances that need to be resolved, and such a period would be extended in order to prepare for the return. The government, May 14, 2010, revised the Immigration Control Act to ensure if the detention period for the immigrants exceeds 3 months, prior to that 3 months expires, there has to be pre-approval given by the Minister of Justice. Also, there's an objection system for such detention, and the legality of such detention can also be reviewed by the judiciary body. So there are legal safeguards in place for the detention of the immigrants. Next, for the asylum seeking migrants, I would like to talk about the prolonged detention period for the refugee seekers or applicants. As was mentioned by the member, yes, it is true that the refugee applicants are in detention. Now, there are some people that are subject to deportation, and they're put at the protection facilities afterwards, and there are other people who have asked for protection or detention at the protection facility before making the application for refugee. The Nigerian and the Myanmar persons that you talked about, they all have lost in the lawsuit litigation, and they either replied for refugee status determination while they were at the protection facility, or they have already gone through the third instance, and the trial went through the final stage, but still this person is not leaving the country even after the third instance ruling was made. So the government is trying to make sure to minimize the detention period of people at the protection facility. And in the first instance or the second instance, if there is a favorable ruling, then we, in principle, release protection, and those people, while in detention, ask for refugee recognition. We make sure that the refugee status determination is completed within 3 months to minimize the period of detention of people at the immigration protection facilities. Thank you.
외국인
Regarding the foreign seafarers issue, trafficking in humans, the MOJ will provide an answer. My name is Jong Hee-hong from the MOJ of Korea. Regarding the employment of foreign seafarers, actually that employment is made based on a labor contract that's entered into by the owner of a vessel and a seafarer that's involved. Because the means such as coercion or tricks have not been employed, as such cases cannot be regarded as trafficking in persons. And concerning the statistics, under the Criminal Act of Korea, not just human trafficking, but also with regards to the act on the aggravated punishment of sex crimes and another law involving the protection of children and juveniles from sexual abuse. We have compiled data based on all those laws. And you asked a question regarding the statistics that we anticipate for this year, the full year. But at this point in time, we cannot provide you with any specific numbers. I ask for your understanding on this. In 2015, and this Filipino woman who has entered Korea based on E6 visa, you talked about the possibility of human trafficking for this case. Actually, this female victim herself, in the course of an investigation, have not claimed that she was a victim. But in the future, actually, later in the investigative process, after she was subjected to a deportation order, she started to make that claim. And as such, as of May 20th of 2015, she was provisionally released from detention as an exception. And at the same time, regarding the act of punishment of the arrangement of sex traffic, if the act of transferring a person to a third party for prostitution, that act is punished as a crime. Thank you.
예, 다음은
Next, Ms. Watwa's last question will be answered. This is related to birth registration of a foreign child in the country. MOJ Immigration Bureau will answer the question. I am Park Yang-ho.
First, in the case of refugees and migrants, when it comes to the birth registration of their child, let me give you some explanation. If you look at the nationality system of the Republic of Korea, we adopt the principle of personal jurisdiction. As such, regardless of one's nationality, if we're going to allow birth registration for all children that are born in Korea, then that system could become conflicting with the nationality system of Korea. As such, birth registration of a child that is born to foreigners, that registration can be made with the diplomatic missions of the country of that child's parents. And at the same time, regardless of the birth registration, we are making sure that the child can have a stable sojourn in Korea together with their parents. And in the case of refugees or refugee status applicants, we are granting legitimate status of sojourn to them in Korea. Next, let me talk about some legislative efforts to improve the existing birth reporting system. We are making efforts to improve the birth reporting system in Korea. We want to complement the system, and this bill has been submitted before the National Assembly at the proposal of the government, and discussions are currently underway in the National Assembly, and we will make our best efforts to make it pass through the National Assembly. Thank you.
이어서
MOJ Immigration Office will answer the question. In relation to the Vietnamese woman, there was a question. According to our Nationality Act, if a parent, a mother or father, if a person is a Korean national, then the nationality is given to the child. But in exceptional cases, whereas in order to receive nationality as a result of birth in Korea, there has to be if there are cases where the parent, the mother or father is not known, or the child has to be an orphan in order to be granted a nationality. But in this case, a mother was very clear. It was known that he was a Vietnamese woman. That is why the child that was born to that Vietnamese woman is not subject to nationality of the Republic of Korea. Next, in relation to visitation rights of children. The Civil Code of Korea provides that if a parent that is not raising the child directly is granted the right to have a visitation with his or her child freely. However, for those cases due to being an undocumented illegal alien. If a person that cannot come to Korea because of personal issues or being an undocumented alien, the law does not ensure visitation right for these people.
예, 다음은
Next, we will provide a response to the questions raised by Sir Lodley. Concerning the definition of a torture, the Human Rights Bureau of the MOJ will give you a response. My name is Kyu Young-hyung from the MOJ. Concerning the torture provisions under the Criminal Act of Korea, assault or a cruel act are defined as torture. So we are not making a limitation to physical torture. And the statute of limitations for this crime is 7 years. Thank you.
I think it would be better for the delegation, members of the delegation, to focus specifically on questions. Be succinct. Next, I will talk about the detention at the correction facilities. MOJ will answer that question. I'm from MOJ.
Actually, the head of the punishment committee will be appointed and decided by the head of the correctional facility out of those people who have an expertise and experiences regarding correction. And the members of the punishment committee will base their decisions on the documentation that's prepared by a specialized investigation team. And when necessary, they will also hear the opinions of the inmates themselves before making a decision as to solitary confinement. And regarding the regulations of correctional facilities, the relevant laws provide relevant provisions. And the relevant authority is the MOJ concerning the supervision of correctional facilities, and the MOJ conducts an audit at least once every year in order to prevent the abuse of protective equipment. And that prison officer who interferes in the process of an inmate who is trying to file a complaint with the NHRCK, that staff or officer will be subject to punishment. And at each of the correctional facility in Korea, we have a system in place where inmates can file the complaint with the NHRCK at any point. And when we construct new correctional facility, we're making sure that the MOJ directive provision regarding the individual space per prisoner is observed. For instance, there could be an inmate who died before the decision on his request for the suspension of execution is made. There is such a case, that is true. However, one thing that I can tell you for sure is this: even if an inmate requests for the stay of execution, medical treatment does not stop at that point. If an inmate files a civil litigation or an administrative process, and if that inmate wants to appear in court, we are making them pay for the use of the vehicles for their transportation. And however, in the case of the inmates who find it difficult to pay such expenses, we don't collect them from them. We still allow them to appear in court regardless. So these inmates who are following the civil procedures, they are given the right to counsel as well. They can have communications with their counsels. Thank you.
예, 변호인
Next, in relation to the right to counsel, that question will be addressed at a later point. Now I would like to talk about the deportation room at the Incheon International Airport. I'm from MOJ, Song So-young.
공항에서
For instance, if a foreigner applies for a refugee status at the airport, we need to make the decision whether that person is entitled to make such a request in 7 days. So we examine whether that person is entitled to make a request for honesty process. And once that examination decides that the case will be referred, then we'll follow with the rest of the process. But if non-referral decision is made, that person will stay in the detention facilities. Starting from October 2014, the Korean government is opening up these facilities to only those people who wish to stay in those rooms. As such, even if you are admitted to the detention facility, if that person wishes to leave, that person can make a free exit and entry into that room. So it's not used as a detention facility.
예, 다음
Next, in relation to conscientious objectors, the answers will be given by the Ministry of National Defense. I am Park Jin-young, issue 22 related to conscientious objection. Military obligation by the Constitution is the duty of a citizen. And also, objectors to such military service, if they're not punished, there could be issues in terms of society, and it could lead to tensions and conflicts in society. And these factors would have to be considered. Even the Supreme Court and the Constitutional Court maintain this position on military service. Next, I would like to give you our position on the introducing alternative civilian service. In the future, well, we would have to continue to see the security landscape on the Korean Peninsula. If there are positive signs that the relationship is improving, and if there's a consensus of the people in terms of introducing the civilian service, alternative service, we will go in that direction to introduce that service. Also, in relation to the system on the publicizing the names of people who are objecting to the military service, it is about illegal objectors to the military service, and this is to disclose their names.
Next, regarding the question concerning assemblies, the National Police Agency will provide a response. My name is Kyung-gyu Kim from the National Police Agency.
집회
According to the relevant laws and assembly, due to collective assault, intimidation, destruction, and arson, if there's a clear possibility or a possibility that a serious threat will be posed to the public order, then such assembly can be prohibited. As you raise your concerns over the police has not prohibited assembly on certain groups or organizers. In 2015, or April 15, there was an assembly organized for the memorial service for the Sewol ferry incident. There was a large group of participants in the assembly and demonstration. However, the demonstration assembly were carried out in the opposite manner to what was reported, and without taking an action against that, it would have led to serious threat to the order of society. That is why buses were used to put up a bus blockade. Even the Constitutional Court recognizes a limited installment of such bus blockades in certain cases. At the assembly and demonstration, if there is a direct confrontation between the participants and the police, it could lead to massive injuries and damage. And in fact, at the assembly that was organized for the Sewol ferry incident, there were more than 80 injuries that were recorded amongst both the participants as well as police officers. Lastly, the organizers of unreported assemblies are punished in accordance with the decision made by the this provision was ruled constitutional by the Constitutional Court of Korea. However, even the assemblies that are not reported in advance, if they're peaceful assemblies, they're insured. And in the disbursement process of such assemblies, a considerable amount of time is given before the assemblies are dispersed, and the police physical force is used to a minimum required extent to make sure that there are no damages caused or done by both of the parties.
예, 다음으로
Next, Ms. Albert Paul questions will be provided with responses concerning the protection of foreigners. The MOJ will provide a response.
법무부 이미
From the Immigration Bureau of the MOJ, my name is Sang Yong-yun, and I would like to provide a response. As was mentioned by the member of the committee, in the past, the environment in these protection facilities were not favorable. However, there was this fire incident at Ihasu Protection Center in 2007, and afterwards, at all these immigration protection facilities, we have installed sprinklers and have used fireproof materials. And a joint fire drill is carried out on a regular basis as a way to build an anti-disaster system. In the case of the foreigners that are kept there in order to support their leisure activities, we are also providing these facilities with the expanded playgrounds so that these protected foreigners can enjoy physical exercises. Per each individual, we are allocating 6.6 square meters. That is the space that is allotted to each individual within the facilities. And also, these specialized protection facilities are supposed to have public health doctors, medical staff, and nurses, along with the medical supplies. In the future, we have a plan to employ psychotherapists so that we can provide psychotherapy to these people. This is an effort that we're making to improve their human rights protection.
예, 다음
Next, in relation to treatment at the correctional facilities, MOJ will answer the question.
준비 안 됐어요. 예.
This is actually overlapping with the previous question, so previous answer, so we will skip this with your understanding. Next, in relation to the freedom of assembly, police agency will answer the question. And if there's any overlap in answers, please let us know. I'm Kim Kyung-gyu from Police Agency. As was previously mentioned, freedom of assembly, in accordance with the laws and the Constitution, is guaranteed as a basic right of citizens. That is my answer. Thank you.
예, 다음 노동조합 문
Next, regarding the trade unions, the Ministry of Employment and Labor will provide a response. My name is Won-do Lee from the Ministry of Employment and Labor. Concerning KGEU, Korean Government Employees Union, the Korean government is granting the right to unionize only to the incumbent officials. However, the bylaws of the KGEU are in violation of such provisions of the law, which is the reason that we do not recognize it as a legitimate institution. In May of 2015, the Constitutional Court of Korea has made a decision in support of the government policy in this direction. Thank you.
예, 다음
Mr. Iwasawa's question will be answered. This is related to LGBTI. The answer will be given by Ministry of National Defense. I'm Park Jin-young from M&D. In accordance with the Military Criminal Act, you asked about the same-gender sex. In the barracks, same-gender sex, given the fact that there's a group life in the military barracks, and there's a need to establish disciplines and order in the military, is prohibited. Currently, in the National Assembly, relevant amendment bills are currently pending before the National Assembly, and there are discussions underway. Thank you.
네, 시간이
We are running out of time. And concerning the questions raised by Mr. Politi, we would like to give you the answers first. Concerning the discrimination against the North Korean refugees who are in the protection center, an answer will be provided by the Supreme Prosecutor's Office. First, concerning this North Korean Defector Protection Center, is designed to provide protection to North Korean refugees, and this is an administrative investigation institution. Concerning the potential human rights violation, as was mentioned, the relief process is informed to these people, and we guarantee a session with the human rights officers. And in accordance with the Act on the Protection of North Korean Refugees, we provide assistance in their settlements in Korea. Thank you. And also for their employment.
예,
Ms. Cleveland's question will be answered. First, in relation to domestic violence, MOJ will answer the question. MOJ Hong Jong-hee.
Concerning the suspension of prosecution for the perpetrators of domestic violence, you've expressed some concerns as to this provision. However, this suspension of prosecution for these people, conditional upon counseling, is determined in consideration of the past crime records, contents of the crime, and the perpetrator's regrets over the act that he or she committed. And that suspension is made based on receiving counseling. As such, if the perpetrator fails to receive counseling, then the case can be prosecuted as a criminal case again. It could take a lot of time before reaching a ruling for these types of cases. And as such, this suspension of prosecution that can be facilitated by a prosecutor has an advantage of handling this case expeditiously.
예,
In relation to the immigrant workers, Ministry of Employment and Labor will give some brief answers. I'm Yang Seung-jun. So let me give you my answer in a faithful manner. There is true that there are some certain limitations in the change of workplace, but in order to protect the rights and interests of migrant workers, we have been going in the direction to ease the restrictions on the change of workplace. In 2012 July, as a result of improving the system, In 2006, there were 18,867 people that changed their workplace. The number increased in 2013, right after the improvement was made, was increased to 53,309 persons. So there has been a dramatic increase in terms of people that were able to change their workplaces. Also, the government is conducting regular inspection and guidance on those workplaces that employ a lot of foreign workers, especially in order to protect the labor conditions of people that are involved in farming and fisheries. We have conducted inspection on about 3,000 workplaces last year. And about 30% of the workplace inspection was allocated to the fisheries, livestock and farming industry, and about 40% of the allocation was also granted to the farming and fishing industry, livestock industry. And if there are any workplaces that provide excellent dormitory environment to the immigrants, they're able to get more incentives. And this is leading to voluntary improvement of the accommodation facilities for migrant workers.
예, 위원님들 주신 질문
Of the questions that were raised by the members of the committee, Sir Lowley raised a question regarding the right to counsel. Mr. Iwasawa again posed a question regarding the HIV testing base station investigation and the confirmation of location information. And concerning the questions raised by Ms. Cleveland concerning the LGBTIs, later on, within 48 hours, we will provide you with the responses to those questions. With that, we would like to conclude our responses.
Thank you very much. Unfortunately, we don't have any more time. However, I will allow my colleagues to make extremely short interventions so that the delegation can then reply in writing to any concerns or concrete follow-up questions that members of the committee might have. Mr. Shani asked for the floor. You have the floor, sir.
Thank you very much. I would appreciate if I appreciate all the answers. With respect to the answer concerning Article 44 of the Act on Promotion of Information, could the delegation please provide us in the 48 hours some statistics on the number of applications of advice to remove information from website or other public domains? And with respect to Article 3071 of the Criminal Code, could the delegation also provide us with information as to whether it was considered to formulate a narrower exception that would capture the type of examples used by the delegate? Thank you very much.
Gracias, Sir Nigel.
Thank you. Sir Nigel, you have the floor.
Thank you very much. So two very brief questions. One relating to the question of mental torture. I note that the response is that cruel treatment is not restricted to physical ill treatment. Can the delegation bring to our attention any cases of mental torture that have been prosecuted under the provision in question? I think it's Article 125. On conscientious objection, I note that the publication of names is only for illegal conscientious objectors. I haven't heard the delegation explain what legal conscientious objection is permitted in the state party. Thank you, sir.
Gracias.
Thank you. Ms. Waterfall.
Thank you, Mr. Chair. I also appreciate the answers I get. I want to have one clarification, and that was on the example of the Vietnamese woman, and it relates to the undocumented parent. She was not known by the authorities as to be a Vietnamese woman because she didn't reveal her nationality. So she was, for the authorities, she was an undocumented parent. Thank you.
Gracias, señor.
Thank you. Mr. Mimosa, please.
Very quickly, to thank the delegation for the briefing and for the explanations. But I'd like to say generally that and to those to whom much is given, much is also required. The Republic of Korea is in a league of its own, so instead of chest thumping for being ahead of many other countries, there is a lot that is expected out of you, and you are not being forthcoming just because you are a lot better than others. No, you are in a league of your own, and that is why we hold you to a different standard. I thank you.
Muchas gracias.
Thank you very much. I'll now give the floor to His Excellency in order to provide his concluding remarks. You have the floor, sir.
Mr. Chair, distinguished members of the committee, first, on behalf of the Korean delegation, I'd like to extend my appreciation to the members of the committee for the views and comments during the review of the fourth periodic report. The Korean delegation has done its best to answer questions faithfully and to address any issues during the review. We will, through a written submission, provide additional materials to address any insufficiencies. I am, however, certain that the constructive dialogue between the committee members and the Korean delegation will be of great help to the Korean government in deciding how to implement additional human rights policies and practices. After the examination of the third periodic report in 2006, the Korean government undertook many policy reforms to guarantee and protect human rights on the basis of the committee members' suggestions. Such reforms include the expansion of human rights education, the withdrawal of the reservation of Article 14, Paragraph 5 of the ICCPR regarding the right to be reviewed by a higher tribunal, strengthening responses to violence against women and children. Implementation of Disability Discrimination Act, enacting provisions for the protection of foreign workers, expansion of measures to achieve gender equality, and improvement of criminal procedure in our criminal justice system. In a similar fashion, your suggestions during this session will provide an important foundation for Korea's future policies on the promotion and protection of human rights. In particular, considering our highly pluralistic and developing human rights circumstances, the Korean government will continue to be in pursuit of establishing balanced and comprehensive human rights policies, accommodating diverse public opinions from every sphere of our society. Most importantly, in this process, we'd like to place a high priority on implementing recommendations of your prestigious Human Rights Committee. As a member state of Human Rights Council, Korean government will make every effort to guarantee domestic human rights and to fortify its cooperation with the international community for the promotion and protection of human rights within and outside of Korea. Finally, Mr. Chair, I want to sincerely express again my deep gratitude for the efforts of the committee members during this review. I'm confident that we will continue our close cooperation in the very important and essential field of human rights advocacy. Thank you.
Muchas gracias.
Thank you very much, Your Excellency, Mr. Kim. This brings us to the end of our dialogue. Obviously, it's very difficult to summarize the discussion that we've had over the past 2 days, so I'd just like to reassure the State Party that we grant the same kind of treatment to all states that come before the Human Rights Committee. And we have been very happy to have you here. And we always extend a warm welcome to all states who come to hold a dialogue with us. Now, obviously, a great number of issues have been raised. I'm not going to give you an exhaustive list, but I would like to highlight that since there's been a withdrawal of the reservation, we'd like to see the withdrawal of the reservation of 22, just as we've seen the reservation under Article 15. Because we don't really see from the dialogue why you need to maintain that reservation. And as Excellency said, you're going to give the highest priority to the Human Rights Committee's observations and comments. So we very much hope that you will do this through an effective mechanism in order to be able to comply with our recommendations and the provisions of the optional protocol, particularly when it comes to conscientious objection. Here, the committee has a very clear stance on this issue. And for me, I've had trouble hearing conscientious objectors described as criminals when really they are exercising a right. So we very much hope that you will be able to comply with the provisions of the covenant in this area, and also to ensure that the human rights provisions are aligned with the Paris Principles, and when it comes to the operation of Korean businesses abroad, we want to ensure that they comply with human rights in their operations. Mr. Iwasawa raised the issue of equality and non-discrimination when it comes to various people groups, particularly the LGBTI population, and of course, counterterrorism measures must also effectively comply with the provisions enshrined in the Covenant in the terms that Mr. Shani outlined in his concern. Regarding torture and mistreatment, this is another issue of concern. The use of certain protective measures, sometimes as a form of punishment, are not compatible with the Covenant, and therefore obviously the right to integrity is crucial. Legal aid, access to a lawyer, I would refer you to our General Comment 32, which provides very helpful guidelines for the state to be able to bear in mind the need for the exercise of defence. Then freedom of assembly, freedom of expression are crucial in a democratic society, and we have had difficulties during this dialogue to ensure that this issue is fully understood. We very much hope that after this dialogue you will take the legislative measures and other measures necessary to ensure that these rights are fully given effect to. Finally, to people groups that are particularly vulnerable, that require attention, are those living with HIV, and the need not to stigmatize these individuals based on the various measures my colleagues referred to, and of course the migrant population, due to their very situation, need more protection in general in order to ensure that their human rights are guaranteed and upheld. I'd like to thank you all very, very much for this dialogue and for the very impressive numerous delegation for having so actively participated with us. I know that we've run out of time, but we look forward to the remaining responses within the next 48 hours so that we can duly adopt our concluding observations. I wish you a very safe trip back to Seoul, and I'd also like to extend my warm thanks to the interpreters for the extra time that they have allocated us. Thank you very much. You're very welcome. Thank you. The session's adjourned.